Have you ever wondered, when speaking to a person on the phone, whether the content of the conversation can be accessed by a third party? Good day, esteemed viewers. My name is Balikis Lasisi. I'm a 500 level law student of Olabisi Northern University, Agboeboye, and an undergraduate trainee at Allen Telecoms Academy, proudly sponsored by Allen Solicitors. Today, I'll be taking you on an insightful journey through the laws governing the interception of communication in the telecommunications industry. For the purpose of this presentation, I'll be making references to the Nigerian Communications Act 2003, hereinafter referred to as the NCA 2003, the Cyber Crimes Act 2015, and the Lawful Interception of Communications Regulations 2019, hereinafter referred to as the 2019 regulations. At the end of this video, we will be able to know what constitutes lawful and unlawful interception of communication, whether interception of communication is a breach on a fundamental right to privacy or in the protection of public interest, the processes of intercepting communications, the legal framework guiding the interception of communications. Since the early days of electronic communications, communicating individuals have generally had an expectation that their communications will remain private and not accessible by a third party or the state. However, this expectation has not always been fulfilled due to the secret interception of communications by an unauthorized third party. The general expectation that an individual's communication will remain confidential and not accessible by a third party is based on the fundamental right to privacy. For example, Article 12 of the Universal Declaration of Human Rights, which guarantees the right to privacy, family life, and protection of reputation. Consequently, the interception of private communications raises concerns for the protection of privacy rights. However, privacy rights are rarely absolute, as there is a need for such rights to be balanced with the protection of public interest, such as assisting the law enforcement agencies in apprehending criminals or for public safety. It is important to note that there are two ways of intercepting communications: the lawful interception of communication and unlawful interception of communication. But emphasis will be laid on the lawful interception of communications. Now, what is lawful interception? Lawful interception refers to a legally authorized process by which a communications network or service provider gives authorized officials access to the communications of individuals or organizations. It is a telecommunications-driven process firmly regulated by the Nigerian Communications Commission, hereinafter referred to as the NCC, and the 2019 regulations. In everyday terms, when you put a call through MTN, Airtel, Glo, or T2, interception occurs when the conversations of that call can be accessed by an authorized security agency. Moving forward, for an interception activity to be lawful, it has to be conducted in accordance with legal provisions following proper authorization from an authorized agency. Hence, an unauthorized interception of communications by a law enforcement agency will be considered to be unlawful and a violation of human rights to privacy, as provided in Regulation 5, the 2019 regulation, and Section 12 of the Cyber Crimes Act 2015. Section 147 of the NCA 2003 provides that the Commission may determine that a licensee shall allow authorized interception of communications. In similar vein, Regulation 4A and B of the 2019 regulations provide that it is lawful for an authorized agency listed in the regulation to intercept communications where the interception of such communications relates to the use of communication services provided by licensees to persons in Nigeria or outside Nigeria. Here comes the question: who are the authorized agencies? Regulation 12 sub 1A and B of the 2019 regulations provide for the agencies authorized to intercept communications as A, the Office of the National Security Advisor, represented by the National Security Advisor, who shall not be below the equivalent of an Assistant Commissioner of Police, and B, the Office of the State Security Services, represented by the Director, who shall not be below the equivalent of an Assistant Commissioner of Police. How are intercepted communications handled? Regulation 6 sub 1 to 4 of the 2019 regulations provide for the storage of intercepted communications, in which intercepted communications are to be stored only for the period necessary for the investigation, and they must be destroyed as soon as the investigation concludes. Also, if a particular intercepted communication is to be admitted as evidence in court, all other copies of such communications must be destroyed. Furthermore, intercepted communications must be kept confidential and shall only be shared for the purpose of investigation. There are two ways of intercepting communications: with a warrant and without a warrant. Regulation 8 of the 2019 regulations provides for interception of communications with a warrant and states that it shall be lawful to intercept communications where 1. It is done with the consent of one of the parties to the communications, where there is an incontrovertible proof of such consent. 2. One of the parties to the communications is aware of such interception and has sufficient reasons to believe that the interception is due to imminent danger or threat to national security. And lastly, in the line of business, of course, recording and monitoring of communications is very important in the line of businesses. Now, Regulation 7 of the 2019 regulations provides for the applications to intercept with a warrant, and Regulation 7 sub 1 of the 2019 regulations provides that application for a warrant to intercept must be made to the judge of a federal high court, in which the judge assesses whether the conditions for the warrant are met on the grounds provided in Regulation 7 sub 3A to E of the 2019 regulations. What are these grounds? A. In the interest of national security. B. For the prevention or investigation of a crime. C. For the protection of the economic well-being of Nigeria. D. For public safety or public emergency. And E. To comply with the International Mutual Assistance Agreement. Furthermore, Regulation 12 sub 4 of the 2019 regulations provides that applications to intercept without a warrant can be provided for in urgent situations, provided that an application for a warrant must be obtained within 48 hours of such interception, and in a situation where the application for such warrant is not granted or denied, the interception must be stopped or it will be considered unlawful. Also, Regulations 12 sub 2 of the 2019 regulations states that an application for a warrant must be made through the Attorney General of the Federation, provided that the applicant shows evidence of authority from a relevant jurisdiction. Regulations 12 sub 3 of the 2019 regulation provides that a warrant shall be in writing, shall contain the facts and circumstances alleged by the authorized agency, shall be contained under any of the grounds mentioned earlier in Regulation 7 sub 3A to E of the 2019 regulations, and must also be supported by an affidavit on oath stating that intercepting the communication was the only means of obtaining relevant information for which the application for a warrant is needed. What are the contents of a warrant? Regulation 13 sub 1 provides for the content of a warrant, and they are identification of the subject of the interception, identification of the authorized agency, the name and signature of the authorizing judge, the duration of the warrant, the date of the issuance of the warrant, and conditions for which the application for the warrant is needed. Now, we have a duration, amendment, renewal, and cancellation for a warrant, and this is provided in Regulations 14 of the 2019 regulations. For a duration of the warrant, Regulations 14 sub 1 of the 2019 regulations provides that a warrant shall be granted for an initial period of 3 months or lesser than that as the judge may deem fit. Regulations 14 sub 2 provides that a warrant shall be amended at any stage within the validity of that warrant. Regulations 14 sub 3 of the 2019 regulation provides that a warrant shall be renewable at any stage before the expiration of the warrant, and Regulations 14 sub 4 provides that a warrant shall be cancelled, and a cancellation of warrant shall be made by an authorized agency to the judge. Moving further, there are instances where the regulation establishes non-compliance, establishes penalties for non-compliance with the rules in the regulations, and Regulation 16 sub 1 of the 2019 regulations provides that in a situation where there is non-compliance with the regulations of intercepted communications, the penalties for non-compliance in such situation is a fine of 5 million naira, and if the contravention persists, a 500,000 naira fine for each day the contravention persists, and also the revocation of a licensee's license is also another penalty. Also, the court can grant an injunction for a specific performance in such situations. Now, there are conditions in which a warrant can be encrypted or protected. What happens in such situations? Regulations 9 sub 1 of the 2019 regulation provides that in situations where a communication is encrypted or protected, the licensee who is in possession of such communication shall give the key, code, or access to such encrypted communication to the authorized agency. Also, Regulations 19 sub 1 of the 2019 regulations provides that all authorized agencies shall keep logbooks of all intercepted communications, and Regulations 19 sub 2 provides that the logbooks must be kept confidential. The contents of the logbooks must be kept confidential and shall only be used for the purpose in which the communication was intercepted. Regulation 3 of the Regulations 19 sub 3 of the 2019 regulations provides that an annual report must be made on the logbooks, and also an annual report must be made on the conclusion of all intercepted communications annually, and such reports must be submitted to the Attorney General of the Federation not later than the first quarter of the following year, and this is provided in Regulations 19 sub 4 of the 2019 regulations. Finally, if a licensee believes that they have been wrongfully intercepted, such person can notify the NCC or apply to the judge of a federal high court for a judicial review. In conclusion, interception of communications is fundamentally telecommunications based. It is anchored on the NCA 2003 and the Lawful Interception of Communication Regulations 2003, with the telecoms operators at the center of compliance. The law seeks to strike a delicate balance. While Section 37 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, guarantees privacy, interception of communications is permitted in clearly defined circumstances, always under judicial supervisions, and for the protection of the public or the public's interest. For more information, kindly visit www.alemsolicitors.com or the NCC's website. Thank you.